Welcome to Chapter 12, the practical sequel. Last chapter gave you the drama, today you get the toolkit, the instruments that make transfers lawful to the vast majority of countries that will never see an adequacy decision. Here's what's in the box. First, the workhorse of global data flows, Standard Contractual Clauses, including the 2021 modernized set with its 4 modules and its clever docking clause. Then, the aristocrat of transfer mechanisms, binding corporate rules, the internally binding constitutions that multinationals build for intra-group flows, and the demanding approval journey behind them. Next, the newer arrivals, codes of conduct and certification mechanisms as transfer tools, promising but still finding their feet. Then, we descend to the emergency exits, the Article 49 derogations, explicit consent, contract necessity, legal claims, vital interests, and why the EDPB insists these doors are for occasional use only, never a business model. And finally, the discipline Schrems II created, transfer impact assessments, the 6-step methodology, how to evaluate a third country's surveillance laws, and the supplementary measures, technical, contractual, organizational, that can rescue a risky transfer or fail to. By the end, you'll be able to take any transfer scenario and select, justify, and fortify the right mechanism. Let's open the toolkit. Let's start with the instrument you'll encounter most in your career, Standard Contractual Clauses. If adequacy is the golden ticket few countries hold, SCCs are the sturdy passport everyone else uses. The concept is simple and clever. The European Commission drafts model contract clauses that embed GDPR-grade protections, exporter and importer sign them, and the contract itself becomes the appropriate safeguard under Article 46. In June 2021, the Commission released fully modernized SCCs, replacing sets that predated the GDPR, and the redesign is genuinely elegant. The new clauses are modular, one document, 4 configurations. Module 1 covers controller-to-controller transfers. Module 2, controller-to-processor, your company sending data to a US cloud vendor, the most common scenario by far. Module 3, processor-to-processor, that cloud vendor sending data onward to its own subprocessor. And Module 4, the often forgotten processor-to-controller, an EU processor returning data to its non-EU client. You select the module matching your relationship, and the right obligations snap into place. Several features deserve your attention. The docking clause lets new parties join an existing SCC arrangement later. Brilliant for growing vendor ecosystems, no renegotiation from scratch. Third-party beneficiary rights mean the individuals whose data travels can directly enforce key clauses against the parties. The contract protects them, not just the businesses. And the clauses bake in Schrems II. Both parties warrant they have no reason to believe local laws prevent compliance, effectively mandating the transfer impact assessment we'll reach shortly. 2 rules of hygiene complete the picture. You cannot modify the clause's substance, they work because they are standard, though you may add complementary terms that don't contradict them. And the annexes describing the actual data, purposes, and security measures are not decorative. Vague annexes are the most common SCC failure I see in audits. The contract is only as real as its annexes. Now for the aristocrat of transfer mechanisms, binding corporate rules. If SCCs are contracts you sign per relationship, BCRs are a constitution you write once for your entire corporate family. Picture the problem BCRs solve. A multinational with 60 entities across 40 countries moves employee and customer data internally every minute. Papering every internal flow with SCCs would mean a lattice of thousands of contracts updated with every reorganization. BCRs replace that lattice with one instrument, a binding internal policy that commits every group entity wherever located to GDPR-grade protection. Once approved, data flows freely within the group. The rules travel with the corporate identity itself. What must BCRs contain? Article 47 sets a demanding syllabus. The group structure and contact details of every member. The data flows covered, categories, purposes, destinations. The full suite of data protection principles applied as binding commitments. Enforceable third-party beneficiary rights. Individuals can invoke the BCRs directly. Acceptance of liability. Typically, the EU headquarters answers for violations by any group member anywhere. Training programs, complaint mechanisms, audit programs verifying compliance, and a duty to report legal conflicts. If a member's local law blocks compliance, headquarters and regulators must hear about it. The approval journey explains why BCRs signal prestige. The lead supervisory authority reviews the application, coordinates with other concerned authorities, and the EDPB issues an opinion through the consistency mechanism before final approval. The process is rigorous and commonly takes years. I've watched clients invest enormous effort in documentation, governance redesign, and regulator dialogue before the stamp arrived. So who chooses this path? Large multinationals with dense internal flows and long horizons. The payoff is real. Operational freedom inside the group, a powerful trust signal to customers and regulators, and independence from the fragility of external frameworks. BCRs sail through the Schrems storms untouched. Deep investment, durable reward. Let's meet the newest tools on the transfer workbench: codes of conduct and certification mechanisms. They've existed in the GDPR from day one as compliance instruments, but their career as transfer safeguards under Article 46 is still young and worth understanding for both the exam and the future. The concept for codes first. Under Article 40, industry associations can draft codes of conduct, translating GDPR obligations into their sector's concrete reality. A cloud industry code, a health research code. A supervisory authority approves the code, and an accredited monitoring body polices adherence. Now the transfer twist. A third country organization can adhere to an approved code and make binding enforceable commitments through contract or other legally binding instruments to apply its safeguards, including on data subject rights. That combination, approved code plus binding commitment plus monitoring, constitutes an appropriate safeguard for transfers. Certifications under Article 42 follow parallel logic. An accredited certification body examines specific processing operations against approved criteria and issues a certificate, a visible seal of conformity. A third country importer holding such certification, again paired with binding and enforceable commitments, can anchor transfers on it. Why might these tools matter strategically? Scalability. SCCs require every exporter to contract individually. BCRs suit only corporate groups. But imagine a certified cloud provider or an entire sector under one approved code. Thousands of exporters could rely on a single, professionally monitored safeguard. The EDPB has published dedicated guidelines nurturing exactly this vision. The honest present tense assessment, adoption remains modest. Building codes and accrediting bodies takes years, and the ecosystem is still assembling itself. For today's practice, SCCs dominate. For your exam, know that these mechanisms exist, how the binding commitment requirement works, and their place in the Article 46 family. For your career, watch this space. Tools that scale tend to win eventually. We now descend to the bottom rung of the transfer ladder, the Article 49 derogations. And I want to set the tone immediately. These are emergency exits, not doorways. The article's own title says it: derogations for specific situations. Specific, occasional, exceptional. Hold those words. Here's the roll call. Explicit consent. The individual agrees to the proposed transfer after being informed of the possible risks due to the absence of adequacy and safeguards. Notice the double explicitness. Consent to this transfer with these risks named. Contract necessity. The transfer is necessary to perform a contract with the data subject or pre-contractual steps at their request. You book a hotel in Tokyo, your booking details must reach Tokyo. A cousin derogation covers contracts concluded in the individual's interest with another party. Think travel insurance arranged for you. Important reasons of public interest, recognized in EU or member state law, international judicial cooperation, for instance. Legal claims, establishing, exercising, or defending them, litigation abroad needs the evidence abroad. Vital interests, the person is physically or legally incapable of consenting, the unconscious tourist whose medical history must reach the foreign hospital, and transfers from public registers within the limits of their consultation rules. Then, tucked at the end, the strangest creature in Chapter 5, the compelling legitimate interest derogation. A transfer that fits nothing above may proceed if it's not repetitive, concerns limited data subjects, serves compelling interests not overridden by the individual's rights, and the controller has assessed everything, applied safeguards, informed the supervisory authority of the transfer, and told the data subjects. Look at that pile of conditions. The drafters built a door and then bricked most of it up. In years of practice, I've never seen it confidently used. The structural insight. Derogations lack the one thing adequacy and safeguards provide: ongoing protection in the destination. That's why they're rationed to situations, not systems. The next slide sharpens exactly that boundary. Let's stress test the two most tempting derogations, because this is where organizations talk themselves into trouble and where exam questions plant their traps. Start with the temptation itself. A company looks at the derogations and thinks, why bother with SCCs and assessments? We'll just add transfer consent to our sign-up flow or call the transfer contractually necessary. The EDPB's guidance on Article 49 exists precisely to demolish that plan. Its refrain: derogations must be interpreted restrictively and cannot become the rule. Take explicit consent for transfers. The bar is even higher than ordinary explicit consent. The person must be informed of the specific transfer or set of transfers, the destination, and, this is the distinctive part, the possible risks arising because the country lacks adequacy and no safeguards apply. Essentially telling people your data goes somewhere European protections don't follow and you may have no remedies there. Now ask the practical questions. Can consent buried in terms of service meet that standard? Never. Can you build systematic daily flows on a basis every individual can withdraw at any moment? Operationally absurd. Consent works for the individual, occasional case, the customer who asks you to send their records to a foreign provider, not for infrastructure. Contract necessity gets the same discipline plus an extra fence. The test is objective necessity, a direct and essential link between the transfer and the contract's performance. Booking data to the Tokyo hotel, necessary. Customer data to a foreign analytics platform because insights improve service, not necessary. That's preference wearing necessity's clothes. The extra fence, the EDPB, reads this derogation as available only for occasional transfers. Systematic, repetitive flows exceed it even when each transfer connects to a contract. The clean decision rule to carry away. Derogations answer, can this transfer happen? Singular. Article 45 and 46 answer, can these transfers happen? Plural. The moment you're describing a flow rather than an event, climb back up the ladder. Now for the discipline that Schrems II created overnight, the transfer impact assessment. Remember the court's logic. Contracts bind companies, not governments. So before relying on SCCs or any Article 46 tool, you must verify the destination's legal reality lets your safeguard actually work. That verification, structured and documented, is the TIA. The EDPB's recommendations 01/2020 give the canonical 6-step method, and I want you to know it as a story, not a list. Step 1. Know your transfers. Map every flow, including onward transfers and remote access. You cannot assess journeys you haven't traced. This is the cartography habit from last chapter paying off. Step 2. Identify your tools. For each flow, which Chapter 5 instrument carries it? Adequacy, SCCs, BCRs, a derogation? Adequacy flows stop here. The Commission did the assessing. Derogation flows stop too. They are exceptional by nature. Everything on Article 46 safeguards proceeds. Step 3. The heart. Assess whether the destination's law or practice impinges on your safeguard's effectiveness. Focus especially on surveillance and government access rules, measured against the European essential guarantees we'll detail shortly. Step 4. If the assessment reveals problems, adopt supplementary measures that restore essential equivalence. Next slide subject. Step 5. Take procedural steps your measures require. Some contractual additions may need regulator involvement. Step 6. Re-evaluate at appropriate intervals. Laws change, practices change. Your paper conclusion from 2022 is not evidence about today. 2 practice notes from the field. First, assess the importer's lived experience. Has it received government access requests? Can it document its history? The 2021 SCCs actually oblige importers to help with exactly this. Second, write everything down. The TIA is accountability made concrete. When a regulator asks, "How do you know this transfer is safe?" the answer is a document, dated, reasoned, reviewed. Or the answer is a shrug, and shrugs are expensive. Let's get inside steps 3 and 4, the legal assessment and the rescue toolkit, because this is where TIAs are won or lost. Assessing a third country's law sounds academic until you know what you're looking for. The questions are pointed. Can public authorities compel your importer to disclose the data? Under what conditions? With what oversight? Do surveillance programs reach the data in transit or at rest? Are there limits of necessity and proportionality, independent authorization, and can affected individuals seek redress before an effective body? Where the legal texts are ambiguous, the EDPB allows you to consider documented practice, but with discipline, objective, reliable, verifiable sources, case law, official reports, credible expert analyses, not the importer's cheerful assurance that nobody ever asks us for data. Suppose the assessment finds genuine problems. Enter supplementary measures in 3 families, and here's the crucial hierarchy. Only technical measures can stop an authority that legal process cannot be resisted. Contracts and policies bind companies, not states. The technical stars: strong encryption in transit and at rest, with keys held exclusively in the EU by the exporter if the importer cannot decrypt. Compelled disclosure yields ciphertext. Pseudonymization, where the re-identification key never leaves Europe. Split processing, distributing fragments so no single jurisdiction holds an intelligible whole. Notice the pattern: protection that survives even a lawful order abroad. Contractual measures then reinforce transparency obligations. The importer reports access requests where legally permitted, commitments to challenge orders in court, warranties of no backdoors. Organizational measures complete the set: internal policies, strict access governance, data minimization before transfer. And the honest ending the EDPB insists upon: sometimes no combination works. The classic hard case: a cloud service that must process data in the clear within a problematic jurisdiction. Encryption defeats the service's own function. Where essential equivalence cannot be secured, the conclusion is suspend or end the transfer. ATIA that can never say no isn't an assessment, it's a ritual. Let's consolidate this chapter's methodology by giving its 2 source documents their proper place, because exam questions cite them by name and practitioners live inside them. Recommendations January 2020 on supplementary measures is the operating manual, the 6-step roadmap you now know, the 3 families of measures, and, invaluably, annexed use cases showing where transfers can be saved and where they cannot. The document's quiet radicalism is worth appreciating. It converted Schrems II from a court ruling into a repeatable professional procedure, something a compliance team can actually execute, evidence, and defend. Recommendations, February 2020, on the European Essential Guarantees is the measuring stick, distilled from the case law of the Court of Justice and the European Court of Human Rights. When Step 3 asks whether foreign surveillance law is acceptable, these 4 guarantees are the test. 1. Processing must rest on clear, precise, and accessible rules. People can foresee when the state may reach their data. 2. Necessity and proportionality with regard to legitimate objectives must be demonstrated. Bulk, indiscriminate collection fails here. 3. Independent oversight must exist, a court or equivalent body supervising the surveillance. 4. Effective remedies must be available. Individuals can challenge unlawful access before an independent authority with power to bind. Notice something satisfying. These are exactly the standards on which Safe Harbor and Privacy Shield were executed. The guarantees are the Schrems saga codified into a checklist. Two closing disciplines from the EDPB's framing. Objectivity. The assessment measures the destination's legal order, not your risk appetite. The probability of enforcement mattering less than the legal possibility of access without guarantees. And currency. Reassess on schedule and on trigger events, new surveillance statutes, new case law, changes in your data flows. Step back and admire what you now possess. A complete transfer methodology. Map, choose the tool, test the destination, fortify or refuse, document, repeat. That is the whole game, and you can now play it. Magnificent work. With chapters 11 and 12 together, you now command the entire international transfer regime. The why, the history, the adequacy list, SCCs and their modules, BCRs, the narrow derogations, and the full TIA methodology with its supplementary measures. This is the domain practitioners find hardest, and you've just crossed it with a map in hand. The usual brief checkpoint. If this playlist is moving your preparation forward, subscribe to the channel. It unlocks this series plus every other certification playlist we publish, and it keeps free structured training like this coming. Stay with the sequence too. Next chapter, we return home from our international journey and ask a deceptively simple question. Who does the GDPR actually apply to in the first place? Territorial and material scope, the establishment and targeting tests, and the exemptions, including why your family photo album isn't regulated, but your doorbell camera might be. And when you're ready to convert this knowledge into exam performance, our complete CIPP/E course on Udemy delivers the practice layer, chapter quizzes, full-length practice tests in the real exam style, role-play scenarios like running a TIA for a skeptical business team, and downloadable revision toolkits. The link is in the description below. Take a well-deserved break, and here's your self-test for the road. Name the 6 TIA steps from memory. Then join me in chapter 13. See you there.